There's one final case set for argument this morning. It's Dawn Wallace versus William Davies. It's case number 29379. See counsel for both parties, so each of you will have 15 minutes to present your arguments to the court. Attorney Tyler, if you represent the appellant, you have up to 5 minutes for rebuttal. If you choose to exercise that time, let me know, and I'll keep track of that for you as well as it's posted on the television there. Don't think there's any minor children on this one, as I recall, so we don't need to worry about that. The court has read the briefs, and we are prepared to proceed. You would both argue from the podium and keep your voice up since we do record the arguments. Sir.
Thank you, Your Honor. My name is Charles Taylor Sr. I represent Dawn Wallace. In this matter, I would like to reserve the 5 minutes for rebuttal.
All right, thank you.
We filed the appeal on behalf of Mrs. Wallace because it is our belief that summary judgment was inappropriate in this case, and that issuance a ruling for a summary judgment was overwhelming against the overwhelming manifest weight of the evidence. In this case, Bonnie Davies, also known as Bonnie Becker, was married to William Davies, and in 2014, she filed for divorce in Summit County. Specifically, when she filed, she had to ask for an expedient hearing, saying that she had cancer, very ill. He was keeping her family away from her. She needed the court to take some certain actions. A year or so later, when she was only weeks from dying, in 2014, when she filed for divorce, she also drafted a will. And in that will, she was specific about how she wanted her affairs to be handled, specifically that her house is her property, not William Davies' property. There was an asbestos case that she was waiting for settlement. She specifically said those funds belong to her. She put in writing in her will, plus in the divorce decree, that everything was to be left to her children and her grandson. Weeks before her death, Bill Davies took her to a law office and allegedly had her to create a new will, allowing him to have everything that she had said in her will and her divorce decree she did not want him to have. The check came after her death for $37,000. Although he said he had a will, Mr. Davies did not open an estate, but what he did, he cashed the check without opening an estate, began to spend the money. Dawn Wallace, when she opened the estate, 6 months later, he came to the court and said, well, I have a fresher will. The money had already been spent. It's our position that there were material facts that existed that should not have allowed the case to be dismissed on summary judgment. It is our position that there was undue influence. Undue influence was asserted on the decedent Bonnie Becker in making what we think is an invalid will. For undue influence to be asserted on a testator in Ohio, there must be a susceptible testator, another's opportunity to exert it, and the fact of improper influence exerted or attempted, and the result showing the effect of such influence. In addition, the courts in the matter of the estate of Kiefer, the court states that undue influence is presumed if the challenging party establishes that a confidential or fiduciary relationship existed between the donor and donee. Because where such a relationship exists, a transfer is looked upon with some suspicion that undue influence may have been brought to bear on the donor by the donee. The Kiefer court goes on to describe what a confidential relationship is and what it would look like. The court states that a confidential relationship exists whenever a trust and confidence is placed in the integrity and fidelity of another. A confidential and fiduciary relationship is one which special confidence and trust is placed in the integrity and fidelity of another. In this case, Bonnie Becker was very ill, dying from cancer, high doses of morphine. In fact, only lived about 3 weeks after this will was created. The Kiefer court concludes and summarizes their analysis by saying the relationship of the parties is important. Bill Davies have said that even though they were divorced, they were still friends. So we believe that there was a relationship of confidence. He states that he took care of her, took her to treatments. So again, we believe there was a relationship of trust and confidence. He had the opportunity and did exert undue influence. Where confidential or fiduciary relationship exists, a transfer of assets is looked upon with some suspicion that undue influence may have been brought to bear. Where a presumption of undue influence arises based on the existence of a confidential fiduciary relationship between the donor and beneficiary, the burden of going forward with evidence shifts to the beneficiary accused of exercising undue influence to show that his or her conduct was free from undue influence. Mr. Davies, who was the ex-husband of the decedent, had the means, the motive, and the opportunity to assert undue influence on Mrs. Becker. Although Mr. Davies and Ms. Becker were divorced, Mr. Davies still resided with Ms. Becker. This unique circumstance of having an ex-spouse being with Mrs. Becker while she was on morphine and other pain medication provided ample opportunities for Mr. Davies to unduly influence Ms. Becker into executing a subsequent will, making him the trustee and executor. Furthermore, Mr. Davies' unique position of being a caregiver for Mrs. Becker creates a confidential fiduciary relationship mentioned in both the Kiefer case and the Young case. Unlike Kiefer, where the court determined that marriage alone does not create a confidential relationship regarding undue influence, here Mr. Davies is not a spouse. It is easily concludable that a confidential relationship exists, giving rise to a presumption of undue influence. In addition, there are clear signs of undue influence that should be litigated in a court of law. Ms. Becker would be considered a susceptible testator given the fact that she was dying of cancer, in extreme pain, and was using medical prescribed morphine and other pain medications.
Was that evidence before the court?
Yes.
In what form?
In our briefs.
Okay. Any affidavits, any medical documentation to support those claims that were presented to the court?
No.
And counsel, I understand the argument is about burden shifting, but what would be the argument regarding the impact of the testimony from legal counsel and her conversations with the decedent surrounding the decedent executing that will? I mean, does that testimony factor in on whether or not the court impermissibly shifted the burden?
Well, I would think that it provides more evidence for the jury to use to determine whether or not there was undue influence.
Okay. And to that end, then, when faced with testimony from legal counsel who had firsthand knowledge of the decedent stating, "I'm doing this for many reasons," how much is in the record to negate the undue influence allegation based on the statements of counsel?
What is in the records is Bonnie Davis' own statements about her affairs. And one exception to hearsay is Rule 804. If a decedent is dead, is unavailable, then those statements used of the decedent is able to be used as evidence. That was in the record. All the things she said clearly about her property, what she wanted to happen, is in the record. Furthermore, even though Mr. Davies said that he had a will, again, he didn't open an estate. He went and started spending money. The jury might find by that behavior, knowing he had a will in the process, he didn't use it, is that he's a person that could not be trusted, and they don't believe that she created this new will. So I think the best statements was Bonnie Davis' statements herself, and again, one exception here says Rule 804, so we should be able to use that in the court for the jury to determine whether or not there was undue influence.
Was the later will proffered by Mr. Davies, was that admitted?
It was admitted about 7 months after Dawn Wallace filed her will. It wasn't until it was time for accounting that he finally said, "Oh no, I have this will." because there was another suit filed saying that he had did some things to some estate property. It's only then that he came up with his new will. So a will was filed for 7 months, nothing happened. He got the money in September, he cashed the check, began spending the money shortly after he had gone to an attorney about creating this will. So again, I think that's information, if it's before the jury have to decide whether or not they believe that she was unduly influenced. For summary judgment to be granted, the moving party must demonstrate there is no genuine issue as to any material fact that remains to be litigated. The moving party is entitled to judgment as a matter of law, and based off the evidence, the reasonable minds can only come to one conclusion. I believe that there is facts in this case that made this case improper for summary judgment, and thus we filed the appeal. I have less than 5 now?
Yes, sir. 4 minutes and 48 seconds. You want to reserve that?
Yes, Your Honor.
All right, that's the time you will have for rebuttal. Counsel, you will have 15 minutes.
May it please the court, my name is Nick Schneckenberger and I represent the appellee William Davies in this case. The issue before the court is whether there was enough proof of undue influence to improperly grant summary judgment in favor of William Davies. I would like to first address the issue of the undue influence before summary judgment. Because the trial court with Judge Stormer, she ruled in our favor for summary judgment based on the first element of undue influence, there being no proof once the burden was shifted for a susceptible testator. So, as my opposing counsel stated, I'd like to clear something up factually in the record, and that is that in the original will that Ms. Becker created, there was no provision that left any kind of funds or any property to the grandchild in this case. That original will left everything equally to her children. There was a provision in there that did mention the grandchild in terms of having a guardian named in his favor. And as you guys know, that is not the same thing as being named as a beneficiary. So I'd like to start with the first element of the undue influence being the susceptible testator. And the appellants in this case are relying on the fact that, or claims I should say, that she was dying of cancer, was on morphine and other such medications, and that is what made her a susceptible testator. There is no evidence produced, and none whatsoever. If you turn to page 103 of the record, you'll see the response to motion for summary judgment, and the only evidence produced in support of that was a copy of the motion from the divorce 2 years prior, which I'll get to in a moment. Therefore, once the original motion for summary judgment was filed, there was enough evidence produced there to shift that burden and no evidence to rebut it. The other issue with the divorce that my opposing counsel mentions is that that divorce was 2 years prior to the new will being created. And there is a standard that was mentioned in the judgment entry for the motion for summary judgment, that any evidence that is produced must be within a reasonable time of the new will being created. The reasonable time is at the discretion of the trial judge. In this case, Judge Stormer decided that this divorce decree 2 years prior was not in a reasonable time within the new will being created. And factually in this case, it makes sense that this new will was created because the decedent had custody of the grandchild and decided, since she was raising him along with Mr. Davies, she would like to leave some property to him. And they also mention in their brief and in the argument that Mr. Davies is receiving property out of this estate, which is not the case. The new will leaves half of the property equally to the 5 children and the other half to the grandchild, which is to be held in trust, and Mr. Davies is the trustee. Now, being a trustee is not the same thing as being a beneficiary. Which brings me to the second point of undue influence. Even if you were to say that she was a susceptible testator, there is no confidential relationship here. My opposing counsel cites to Kiefer, which is not even within this court's jurisdiction, and the case that cites to is from the 8th District. And that says that there's a presumption of undue influence if the challenging party establishes that there's a fiduciary confidential relationship between the decedent and the beneficiary. Again, here, there is no beneficiary for Mr. Davies. He is merely a trustee of a trust for a minor. Even if you were to assume that there is a confidential relationship, there is enough evidence in the record in our motion for summary judgment that says that that burden has been shifted back to the appellant in this case, based on the testimony of the attorney that drafted the will, who is an estate planning attorney and does this on a regular basis. And in her professional judgment, Ms. Becker had testamentary capacity and there was no undue influence. Mr. Davies went to the initial meeting with Attorney Mason to have that will done. He was there merely for introductions and had to go to work and left. And that meeting concluded with Attorney Cynthia Mason and the decedent, and one of the decedent's daughters, who is also a plaintiff in this case, was at that meeting. Then there was another meeting after that in which the will was then executed. At that meeting, Mr. Davies was not present. Attorney Mason, you'll see in the record, stated under oath that she reviewed the terms of that will with Ms. Becker, and after reviewing it, Ms. Becker did affirm that that is what her wishes are, and they are properly spelled out, and that will was then executed. Moving on to the third element of the undue influence, and again, these elements, you only move on if the burden has been met for each one. There is case law from this district in Kreider versus Kreider that says that the failure to meet the burden on a single element of undue influence is dispositive in itself. So as I'm going through these, this is assuming that the evidence has been met on their part for both elements. And again, here the trial court ruled this out after element number one. But the third element is probably the most critical as courts have determined, and that is the fact of improper influence actually being exerted or executed on the decedent. And the same case that my opposing counsel cites to, Young versus Kaufman, is coming from the 8th District. And that case said that even the mere existence of undue influence or the opportunity to exert undue influence is not sufficient to invalidate a will. General influence is perfectly acceptable. There must be some burden being met to prove something more, is the way that that has been interpreted, and that something more is undue influence. And to define that, the Ohio Supreme Court in West v. Henry has stated what exactly is undue influence without these elements. Just an overall definition of undue influence is something that is so overpowering for the mind of the testator that it destroys their free agency. It makes them express the will of another individual rather than their own. And even the mere presence of influence is not sufficient. Undue influence must be present or operative at the time of the execution of the will, resulting in dispositions which the testator would not otherwise have made. Again, this brings us back to the reasonable time issue. The only evidence produced to rebut this is the divorce 2 years prior. And as the Ohio Supreme Court has said, and this court has held numerous times, actually back in 2017 with Duvall versus Denon and Kreider versus Kreider, that if one single element of that undue influence is not proven, there's not enough evidence to support it, there is no undue influence. In addition to that, the Ohio Revised Code says under 2107-74 that on the trial of any will contest, the order of probate is prima facie evidence of the attestation, execution, and validity of the will. The second will at issue here was successfully admitted to probate court, meaning that just on its face of being admitted, it is valid. In my opposing counsel's brief, he mentions that Mr. Davies and Ms. Becker were adamant about getting this new will done. However, I would like to raise the issue that, again, there is no proof of that. There are no statements, no affidavits, no depositions. There was no discovery done on the part of the plaintiff in this case. And in addition to that, the only evidence that was produced was on the defendant's part, which I think has met the burden for undue influence. Now, that being said, even if you can prove there was undue influence, we then jump to the summary judgment issues. And going through the elements of summary judgment, we're back to, was the burden properly shifted? And here, the burden was properly shifted because there is enough evidence to shift that burden. And then once that burden is shifted, they have a duty to reply with not just facts and allegations, but evidence under 56E to overcome that burden. And there was no evidence produced under the rules of summary judgment.
The burden that was presented by you to shift that burden would have been the deposition of the attorney?
The deposition of the attorney. We also had a deposition produced for the second witness to the will. We produced a deposition of the grandchild, just discussing the relationship between the decedent, and the grandchild, and the defendant in the case. That alone would have shifted the burden, and we are respectfully asking this court to affirm the decision of the probate court, saying that that burden was shifted and there was no evidence produced to rebut it. And again, the only evidence that was produced was the divorce motion that was filed 2 years prior, talking about the mental and physical condition of the defendant in this case. And even after that divorce, Your Honors, it's in the record that the depositions, everybody has testified to this that was deposed, is that the decedent made it clear to everybody that she did want to remarry the defendant in the case, that they continued residing together even after the divorce. He never left the house. He was caring for her, and they did intend on remarrying. In fact, that was one of the things that was brought up to the attorney who drafted the new will, was the fact that they were getting married, and she ended up passing away before that was able to be done.
Did she testify to that in her deposition?
The attorney?
Yeah.
She did, yes.
Curious about the money that was spent, 30-some thousand, was that a probate asset or not probate?
It is, yeah, Your Honor, that money was not spent. It is currently sitting in the probate estate.
Oh, it is.
It is in there. There was an accounting filed, I think, within the last 2 months for the probate estate, and those funds are in there as an asset.
Why the delay in filing the new will?
That is a good question, Your Honor. I do not know the answer to that. Myself and our firm are not handling the estate administration itself. I don't know if the settlement proceeds maybe came in and then he decided to open the estate, because there are not many other assets in this estate. That is almost the only one, I believe. So to conclude, we do respectfully ask that this court affirm the decision of the Summit County Probate Court granting summary judgment and denying the request on the part of the appellant, saying that when that decision was granted against the manifest weight of the evidence, we believe there is plenty of evidence in support of the motion for summary judgment, and none that is applicable to the response to the summary judgment, mainly because the only evidence produced was not showing the testator's mental state within a reasonable time of that new will being created. Are there any further questions?
Questions? No. There appear to be none, so thank you.
Thank you.
Counsel, you'll have 4 minutes and 48 seconds.
Thank you so much, and let me first say the funds from the $37,000 is not there. At the last hearing, the court ordered Mr. Davies and his counsel to provide bank statements as to when the account was open and what is there. And another pre-status is scheduled for January, I think 9th it is. What we would also want to focus on in the first will, the house was left to Mrs. Bonnie Becker's children. You will notice in the second will is not there because Mr. Davies created a death on deed transfer. So that house that she wanted to leave to her children, her first will, he had that house transferred to him upon her death. They argue that he's not a beneficiary. He is the major beneficiary. So the house that should have gone to her children from the first will went to Mr. Davies on a death on deed transfer. In addition, The question is a good question. Why the $37,000? Mr. Davies outright so-called created this will, but he went out and he took everything. He took the house on a death deed transfer, the money, $37,000. He started spending without opening a estate. I think all those things are in the record, which a jury should determine whether or not this ex-husband, who a wife said in her own words was abusive, wouldn't allow her family around him, took advantage of her and took all of the property that she got in her divorce, that she specifically said in her words she did not want him to have. So while on paper it might seem that William Davies were not a beneficiary, he was the only beneficiary. This has been more than 2 years. No one else other than William Davies have received anything from the estate. He's received the house. He spent the money. Nobody else have received anything. We believe that she was a successful testator, that he used undue influence, he took advantage of her, he's taken advantage of her children. Again, at this point, we believe that there was facts that a jury should have considered. The summary judgment was inappropriate, and we ask that the court would overturn the probate court's decision.
All right, thank you both for appearing this morning and presenting the court with these arguments. The court will take the matter under advisement and issue a decision in due course. The opinion will also be available on the Supreme Court of Ohio's website. And as I said, you will get a copy from the courts on the day it is released. So thank you again for both of you for appearing today.
Thank you.
The court will next convene